SJC-11118 with SJC-11119, Greenberg versus City of Worcester, and Shapiro versus City of Worcester.
Let's proceed.
Thank you, Mr. Chief Justice. May it please the Court, Wendy Quinn on behalf of Appellant City of Worcester. Before the Court in these cases is the issue of whether the presentment requirement of the Massachusetts Tort Claims Act, Chapter 258, Section 4, should be included in the retroactive application of Morrissey versus New England Deaconess Abundant Life Communities, Inc., which brought common law nuisance claims within the scope of the Tort Claims Act. At issue in these cases are nuisance and trespass claims in Shapiro and nuisance claims in Greenberg arising out of surcharges in the sewer system, which were not presented to the City of Worcester pursuant to Section 4.
So what's a plaintiff to do? At the time, do you agree that Asiala was the controlling authority with regard to that?
I'm sorry, Your Honor?
At the time this claim was brought, do you agree that Asiala case, the appeals court case, was the governing authority?
I do agree, Your Honor. However, with the decision in Morrissey and the court's explicit application of that case to the nuisance law, bringing it within the Tort Claims Act, and that the application would be retroactive, it is our position that the plaintiffs in these cases should have been required to present.
Right, well, I understand that, but it's a question of fairness, I guess. So a plaintiff basically has a claim. The plaintiff reads Asiala, recognizes that to be the controlling authority, recognizes that it's not under the Tort Claims Act, and therefore does not give a presentment, because if it did, the response would be, under the appeals court controlling authority of Asiala, this is not a matter within the Tort Claims Act. And now, because the plaintiff doesn't do what would have been not in keeping with prevailing law, you now say the plaintiff loses his or her claim. Why is that a reasonable and fair result?
Your Honor, I think anyone filing a lawsuit against a public employer is certainly on notice of, when alleging wrongful conduct of that public employer, certainly on notice that it could fall within the Tort Claims Act, and there are many provisions that would apply. And you mentioned fairness. I think that fairness in this case is not an appropriate consideration, considering that the presentment requirement has been strictly applied in Massachusetts, and certainly
well, when it comes to determining whether we will retroactively apply it, thereby wiping out claims, certainly the fairness is a consideration in the retroactive application of one of our cases, isn't it?
Isn't the Gray case like that, if I have the name right, about not applying retroactively to claims that were pending at the time?
Your Honor, I would say that certainly the retroactive application is when the court is making judicial decisions about changes in common law, that the rule is retroactive application, and those changes are generally given retroactive effect.
But not if the application will create hardship or inequity under McIntyre, which we most recently in Eaton referenced. And this is exactly that kind of case. We have make a determination about substantive retroactivity, and now, separately apart from that, we need to decide whether the procedural component of that is also appropriately applied in this case. And why is it fair?
And generally, procedural requirements are given retroactive effect. I would say that is the rule, that we're not talking about substantive rights, but.
Go ahead, sir.
The procedural, even when something's when the time for which the procedure would apply has already gone by?
I believe so, Your Honor, and certainly over the years the court has been asked and to review cases where the parties have requested that presentment be told because of various reasons that may have relatively harsh consequences, such as cases in, for instance, the Heck versus Commonwealth case in 1986. The court had indicated that in a situation of mental incompetency, that mental incompetency would not necessarily toll the presentment requirement. Weaver versus Commonwealth, the death of a party would not necessarily toll the presentment requirement.
Talking about tolling provisions, but there's another concept, and that is when there has been on the books a decision, that's how you pronounce it, that says this is not part of the act, therefore presentment's not required. We then change the law. What are the principles that apply to determine whether the procedural requirement of presentment is also retroactive? And if you look at some of our decisions, they seem to say, number of things, including whether application will not further the purpose of the rule and will create hardship or inequity. So wouldn't we apply those considerations? Don't know how we'd come out, but wouldn't those be appropriate to consider?
I would say that in this case, certainly that this court was making changes about the common law, that a person who creates or an entity, a public employer who creates or maintains a private nuisance which causes injury to the real property of another, that was a liability that existed in the common law and still exists certainly under the Tort Claims Act, and allowing, as occurred in this case, allowing someone to call a claim a nuisance or a trespass rather than to simply escape the presentment requirements would rob the municipality of the benefits of the Tort Claims Act, which are certainly, presentment requires, it gives the municipality the opportunity to thoroughly investigate a claim, to disprove fraudulent claims, to certainly pay meritorious ones and prevent future claims, which is certainly part of the Massachusetts Tort Claims Act.
But if the law hadn't changed, you wouldn't have had any of those benefits at all, right?
Well, that's true, Your Honor. But certainly I think the court got it right in Morrissey in establishing that the nuisance claims are subject to the Tort Claims Act. I think that if a party is filing a suit against a municipal employer, certainly counsel in this case is very familiar with filing lawsuits against the city of Worcester and other municipalities, and it was really in these cases an attempt to circumvent the requirements of the Tort Claims Act in order to call it nuisance trespass rather than including a negligence count in this case. In fact, if you look at the Greenberg and Shapiro complaints in these cases, they are even misnumbered because they go from 1 to 4 to 5, because in other cases filed even in this neighborhood, there were negligence counts included, but not in these cases. So certainly.
What are the other issues in this case other than the presentment issue?
Certainly, our position is, even if the court were to find that the presentment requirement is not retroactive, that the various exceptions to municipal liability would apply. Certainly the Chapter 258, Section 10B, the discretionary function exception to municipal liability would preclude liability against the city of Worcester in these cases.
Go ahead.
No, you do.
Well, I take it part of the theory is that this has nothing to do with whether or not the city properly planned for this sewer mishap, but whether or not they executed a plan that had been, or properly executed a plan that had already been approved. Is that a fair distinction or no? And
we disagree, Your Honor. Certainly the plaintiffs in these cases pled the case and argued that it was really the inadequacy of the sewer system that could not handle the rain events. That really, it goes back to the initial plan of the sewers. It's really a planning issue and not a maintenance or construction issue. So certainly a discretionary function, a planning issue that for which the municipality had a great deal of discretion. The adequacy of the sewer system, which the improvements and the construction costs in this case would be estimated at $2,875,000. So it was a situation that involved a high level of municipal planning.
Didn't the town get a commitment to that money when they made an agreement that the MDC could put it flow into the sewer, which is what caused the problem? And didn't they agree to make a substantial payment, 2.8 some million or something like that?
That would be the Commonwealth contracted to make those changes to and upgrade in the sewer system. And certainly we would point to the exception to municipal liability in Section 10J as not being the original cause of the alleged harm in this case.
Can I ask you about that? I see you make that argument in your brief. I didn't see that you made that argument in your motions below, and I didn't see that the judge below addressed the 10J argument. Isn't that waived?
We would argue that it certainly was pled in as affirmative defense, and
But it wasn't argued in your motion.
that's true, Your Honor.
But if I understand correctly, this is here on interlocutory review of the presentment question, right?
Well, that was my
It is,
question.
Your Honor.
Yeah, please answer that question. That was really what my question was. What are the other issues, or are there other issues in this case?
Certainly. We had appealed to the appeals court, and it was taken up by this court sua sponte from the appeals court, and we were certainly appealing the decision on summary judgment.
Denial of the summary
It
judgment.
was a denial. Yes, Your Honor.
So there's not been a trial yet.
There has not. So
But is it before us whether or not you were entitled to it on grounds other than presentment?
I think it is, Your Honor, because in denying summary judgment and a motion to dismiss, the Superior Court had decided that although it would be unfair to hold plaintiffs to the presentment requirement, that the various exceptions to municipal liability also did not apply, and it would be directly addressed Section 10B as not applying, and cited a case, Harry Stoller versus the City of Lowell, talking about basically that the cause of the sewer backup was not a failure in planning, but a failure to implement the plan. And I would point the court, though, as...
You don't get interlocutory review on that, do you? Let's say there was no presentment issue here. Would you have an ability to bring an interlocutory appeal? If the Superior Court judge denied you summary judgment on 10B or 10J?
I think under the doctrine of present execution, Your Honor.
On any of those claims?
When it's an issue of municipal immunity, which may be addressed through the doctrine of present execution.
Two questions. Going back to what Justice Duffley asked, essentially then you're asking us under 10J to award you summary judgment on a ground that you did not argue when you sought summary judgment.
Your Honor, it was, and I should be more clear, it certainly was argued in theory because of the storm events.
Argued in theory, or
well,
did you basically, was the exception in 10J argued as a basis for summary judgment when you sought it? Or did you rely solely on the presentment and 10B?
I believe we did rely on the rain events, certainly that the rain event and the
I
storm event.
understand that you argued those facts. I guess, did the letters, did 10J ever appear in your motion as a ground that exception is a proper ground for summary judgment?
And I apologize, Your Honor. I think it may have.
Okay, let me turn to another question. Just in terms of the facts here, am I correct that the city entered into an agreement whereby the MDC had promised to pay the money and to enlarge the sewer system? Is that correct?
Yes, Your Honor. The MDC was, as part of the contract, had agreed to implement upgrades to the sewer system.
And did that money ever come from the MDC to the city? Did the city ever have that money to do it itself, or was it purely essentially imploring the MDC to do what it promised to do?
Your Honor, the changes have been made at this point. The
No,
construction
but at the time of these events.
And as far as the funding, I'm not sure that the status of the funding at the time that the changes were implemented. I know that they were contracted for in 2005, which is they were supposed to take effect in 2005.
My question is this: is this a situation in which there was an agreement? The MDC said to the city, "Here's $2.5 million. You do it. we'll give you the money, you do it, and the city simply didn't enlarge it, or a situation in which the MDC said, we, the MDC, will pay 2.5 and we will do it, and the MDC did not enlarge the system.
As I understand it, it was the construction undertaken by the MDC so that it was not paid to the city to do their own construction, if that's...
But it was an agreement so that they paid for the right to use Worcester's system, and that was the payment. And the reason they entered into that agreement was because they understood from reports that predated that agreement in 2000 that they were going to need to upgrade it. So in exchange for agreeing to allow the MDC to hook into the system, they made a $2.875 million payment, and the city was supposed to undertake those improvements, right?
As I understand it, it was a Commonwealth construction crew.
Could you clarify that in a 16L letter? Because it's a little,
Certainly, okay.
little unclear from
Certainly.
the briefs.
Well, counsel, your time is up.
Thank you very much.
Thank you.
Good morning, Your Honors. John Masiolik for the Shapiros and Mr. Greenberg.
Mr. Masiolik, are there any issues before us other than the presentment issue?
I don't think so, no.
Did you brief both issues?
No, just really whether there's a retroactive application of the Tort Claims Act consistent with this court's decision in Morrissey is really the only issue before you.
I know, but you did brief the 10J issue and the 10B issue.
I did, yes.
Okay. But you don't think those are before us?
I don't think they're really properly before you, no.
Because
And why would they not be under the governing law with regard to tort claims?
I'm sorry, I don't understand your question.
under the present
Present
execution for immunity.
Right, right. Well, the first thing to say about all of that is that what's before the court on Shapiro is really on a motion to dismiss. And it was just a motion to dismiss that the city filed after Morrissey was decided by this court. And so the city asked the Superior Court to dismiss the Shapiro's claim. The Superior Court had already denied a motion for summary judgment. When the Superior Court denied the city's motion to dismiss, arguing that Morrissey had application to this claim, the Superior Court said, no, we're going to let the claim move forward. And then there was an appeal. So on that procedural track, it would be our position that really what's before you is whether Morrissey has retroactive application to these claims.
And the Greenberg?
And Greenberg is slightly different procedurally, but really it's the same net effect. On Greenberg, the court denied the city's motion for summary judgment. This court then decided Morrissey. The city asked the court, the Superior Court, to reconsider its denial of the motion for summary judgment. The Superior Court did not take that invitation, did not reconsider it, and then the city took this present appeal. Therefore, I would argue that really what's before you is, does Morrissey apply or not?
Okay, but in Kent, there was a exception. I think it was the discretionary function exception, which was raised after a motion to dismiss, and the court decided it under present execution.
Under present, yeah, I think that's a fair game for the court to weigh in on that, but I'm not so sure that really is procedurally the right way to do it.
In this case.
Right.
You know, I'm looking at the Shapiro case and Judge Curran's decision that's, I take it, before us. He says the defendant of city's motion to dismiss and its motion for summary judgment are denied.
Right. He dealt with them both at the same time. I
He
believe.
did. Okay.
Okay.
Judge Curran.
Okay.
Well, if we can, well, let's imagine for a moment that discretionary function is before us. Lobster Pot says the city is not responsible for damages from the inadequacy of a sewer system. Worcester says the problem here was that the sewer system was inadequate to handle the water deriving from the melted snow and the rain. And the MDC had not yet expanded the sewer, so it's a classic inadequacy issue, and therefore discretionary function applies. Why is that not a fair argument?
Well, I think that doesn't fully take into account what the Lobster Park versus Lowell case says. What that case really says is the city is responsible for improper, unreasonable operation of its sewer system. And so as this plays out, what needs to be decided is, are these events a result of bad policy, or are they the result of bad execution, bad operation? And I would suggest to the court that it's all bad execution. The plan,
I'm sorry, is there a problem of execution apart from the failure to expand?
No, that is the problem. The problem of the execution is that the deal that they had with the MDC was never carried out. It was never executed.
And who failed to carry it out, the MDC or the city?
The city. The city,
So
absolutely.
the city had the money?
The city got the money. They got $2.8 million. It's in the
And
report.
were they supposed to do the construction, or was the MDC supposed to?
The city was supposed to do the construction. The report and the memos that are in the appendix all indicate that the deal is, listen, we're going to hook you up to your sewer system, we're going to overload it. Okay, that's fine, but here's some money, and now you go expand it. And the city agreed to that, but they never expanded it, but they got the money. So is that a bad policy, or is it bad execution? I would suggest to the court that it is absolutely bad execution. The retroactivity of the Morrissey decision, I think, is also before this court. And at all times, fairness is always a consideration. And the Shapiros and Mr. Greenberg relied on the state of law and did not make a presentment under the Tort Claims Act in an effort to file a private nuisance claim against the city. They didn't present. We know that. We know that. Instead, they proceeded with a judicially recognized claim, one of private nuisance. And at the time that they filed their lawsuit, presentment to the city for pursuit of a private nuisance claim was simply not required. To require it now is an unfair, inequitable result. And the court at all times should always consider hardship and inequity when reaching its conclusions. I'd also point out that the nature of their claims dealing with whether the city's operation of its citywide sewer system is reasonable is very different than the tortious activity that the defendant was charged with in the Morrissey case. That was classic tortious activity, wherein what was complained of was construction activities that created noise, dust, and the like. This is very much a property law case. It's not like a tort case where there's noise and dust, et cetera, that is causing a so-called nuisance. In this case, it's an effort by the plaintiffs to hold the city accountable for the way that they have maintained their property. So it's very much a property law case, very analogous to the claims brought for surface water runoff or the like. And in this court has repeatedly held that applying rules or changing the rules in the middle of the game prospectively would apply more to tort claims, but only prospectively apply more to contract and property law claims, but not necessarily tort claims. So the end result here should be that the Morrissey decision does not apply retroactively to these claims. When these claims were filed, they were filed appropriately. No presentment was required for nuisance and a continuing nuisance claim, and that's what the Shapiros and the Greenbergs have filed.
I'm sorry, go ahead.
I assume you mean that Morrissey will apply substantively, but that procedurally we will say that the presentment obligation kicks in only upon the date that Morrissey issued.
Right. Yeah, if I misstated that, I apologize. But that's exactly what this court should decide.
You agree that the Tort Claims Act will govern this action?
Going forward, yes.
Okay.
Yes, because now the plaintiffs have an opportunity to present a fair case before and address all of those issues that are bound up in a claim under the Tort Claims Act. Absolutely. But they didn't have that opportunity when they filed the claim. They didn't know to make a presentment, so they didn't.
Can I go back to this issue of who paid what and who was responsible? I'm looking at the memorandum from the Commissioner of Public Works in Worcester to the city manager. And this is the Newton Square area, is that right?
Yes, that's correct.
It says within 5 years of introduction of new flows into this interceptor, the MDC shall design, construct, and inspect sewer improvements in the Newton Square area. The estimated value of this work is $1.4 million. MDC shall design, construct, and inspect sewer improvements in this area. Doesn't that mean the MDC was responsible for this?
That language, but I have to apologize for not knowing what, there may be a subsequent memo to that, but there were the memos in the file in the appendix from all sources led me to conclude that it was Worcester that was primarily responsible for doing the construction work.
Is this I'm not sure this is the agreement. It's the 2000 agreement
Yes.
in the appendix at page 15. This is the only thing I can see quickly. It's a pretty dense agreement, but that Worcester's obligation is to accept wastewater from the MDC in towns at designated points, transport sewage to the treatment plant via city sewer system, own, operate, maintain, and upgrade city sewer system to ensure agreed upon reservations of capacity for the MDC.
Yeah, I see the word upgrade in that sentence as requiring Worcester to make it, their system function the way it should. And when a system like that functions the way it should, it's going to have the sewage going out of people's homes, not back into them. So the upgrade leads me to conclude.
And the other one is that the MDC's obligation appears to be to own, operate, and maintain certain interceptors, calibrate wastewater flow meters as to those interceptors, and report and certify the metered flow to the parties, which doesn't include its own obligation to build or improve.
Right, and there's some logic to all of that because the MDC was bringing sewage into the Worcester system.
Well, they could have done it another way, but
Right.
just looking at this language, that you could draw that conclusion that they weren't obligated to upgrade the sewer system. And what has been done? Did the city upgrade its system since? Is that what council said?
Council did say that.
Yeah.
At the time of these events, the upgrades had not been made. And there's nothing in the record that leads anyone to conclude that the system has been upgraded.
I just meant as some indication as to what was intended in the agreement. Did they actually make the upgrades and use the money to pay for upgrades within the city? It's not in the record, it's not important. Thank you.
Yes, thank you.
I guess let me ask you this. Let's assume that we go through the record and it turns out you're wrong, that what Justice Cordy read was actually the correct assertion and that the MDC had the responsibility to expand and it was the MDC which failed to do what it was supposed to do. Do you lose?
No, the city is still obligated to operate its sewer system in a fair and reasonable way. And what I would suggest that means is they're obligated to operate this system so that it functions as intended, so that the system actually works. So really, since the city and the MDC had an agreement, it's then up to the city to execute that agreement, to make sure the MDC is doing what it should do. In other words, once the extra flow is coming into the system, the city should be ensuring that the MDC, if in fact they're responsible for doing that.
Right, but if the MDC has essentially breached its agreement, what's the city to do apart from suing the MDC? You say, you promised to do this, you promised to do this by a certain time, you haven't done it, and now the city then would be responsible for damages that would arise from the MDC's failure to have done what it promised to do?
But I think there's another option, though, which is stop the flow. Don't increase the flow until those improvements have been made. And if the idea is that we'll start the flow and do the construction forthwith or right away or however these construction activities were scheduled to proceed, that's one way to operate the system. But once it becomes obvious that the system is not going to handle the flow and the MDC has not upgraded it, the city is, well, shut it off at the interceptor point.
Don't
We
the
can-
summary judgment documents support, at least inferentially, accept that they had the obligation, but that but their argument is that it's a discretionary determination not to implement?
Well, I would suggest it's not discretionary. I mean,
But isn't that what this is, in essence, is admitting their obligation, but arguing that they didn't have to execute?
Yeah,
It's
that's
a
the city's position.
discretionary
Yeah.
function.
yeah, but that position.
They never argued that they weren't obligated. It was MDC's fault, did they? Did they, I'm sorry, not argued, claimed in any summary judgment materials?
Right. Well, that's been the theme of the city's argument all along. Has been, you know, it's not just us; it's the MDC too. But that's not really a valid legal argument under these circumstances. I mean, well, it's a valid. It falls on the wrong side of the policy planning execution argument, because at the end of the day, what's happening is the agreement that they've agreed to is not being executed properly. So it's our position that to throw these claims out under these circumstances is simply inequitable, unfair, and it is, in fact, the hardship that this court identified even in the Morrissey decision. Thank you very much.
Thank you.